The U.S. Supreme Court is expected to take up President Biden's student loan forgiveness plan early next year, possibly in February. In the meantime, Biden's $400 billion plan is on hold as a lower appeals court order halting its enactment remains in place. Well, here to set us straight is Young Voices commentator Charles Brandt. Charlie is a student at George Washington University Law School. So, Charlie, thanks for being with us. So what are you hearing from GWU students and others about the president's student loan debt forgiveness plan? Do most support or oppose it?
Well, first off, thank you so much for having me on, Gary. I very much appreciate the opportunity. To be honest with you, I haven't discussed the program much with my students. I've discussed it slightly with my federal courts professor, and namely with respect to standing, which is the doctrine that basically controls the floodgates of the courtroom door. So I haven't really discussed the merits of the case much with my colleagues, nor have I discussed the practicalities of their debt situation.
Well, the president based his executive order on the HEROES Act, but that's only to be used in times of national emergency, is it not? What do you think?
Well, according to Judge Mark Pittman, of the United States District Court for the Northern District of Texas, that is a fair reading of the statute. It was passed on the onset of the Iraq War in 2003 to give the Secretary of Education leeway to waive or modify debt directly in connection with a national emergency, essentially to ensure that those who had taken loans pursuant to the Higher Education Act would not be put in a worse financial situation because of their military service. Now, the statute also includes rather broad language such as national emergency. It is on that basis that the administration argues that the HEROES Act authorizes this mass discharge of debt on a society-wide scale. Essentially, the argument being that COVID-19, the pandemic, is a national emergency. This is despite the fact that the president a few months ago actually declared that the COVID emergency is over. And Judge Mark Pittman actually rather cheekily emphasized that point in his district court holding last month, striking down the program. Now, you mentioned the Supreme Court, and this case is headed to the Supreme Court, but not from Judge Mark Pittman's order. Rather, this is a case from the Eighth Circuit Court of Appeals, where you have 6 states, including Missouri, Nebraska, Arkansas, Iowa, Kansas, and South Carolina, suing the administration for this rather lawless student loan forgiveness program. And the Eighth Circuit found that because Missouri likely had standing, and because the equities, essentially a balancing of fairness factors, weighed or rather counseled in favor of putting the program on hold, they did so. And from that ruling, the administration is headed to the Supreme Court, where oral arguments are to be had in February, and where we can expect a decision both on the merits and standing, well, rather on the merits if there is standing, in June.
Well, you're a law school student. What are most of your professors saying about the potential Supreme Court ruling on this? How do they and you expect the court to rule, and why?
I haven't discussed it much with my professors, I have to be honest with you. What I can say, based on a second-year law student's perspective, is that the big question here is that of standing. Whether or not Missouri has asserted an injury in fact that is fairly traceable to the allegedly unlawful conduct of the defendant, i.e. the Biden administration and the Department of Education, and whether that injury, in fact, fairly traceable to such conduct, is likely, not merely speculatively, to be redressed by favorable judicial resolution. So that is the Article III standing doctrine as set forth by the United States Supreme Court in a case called Lujan versus Defenders of Wildlife, decided, I believe, in the 1990s.
Okay, Charlie, quickly then, how likely would a disfavorable ruling from SCOTUS kill any future action? Would Congress take up the cause legislatively?
Well, I don't think President Biden has nearly enough support in Congress, especially in light of the Republicans taking the House of Representatives in the next couple of months. But he lacked the support even with a united Democratic government, a Senate of Democrats and a House of Democrats. He lacked the necessary support because more moderate centrist Democrats, and especially the Senate, were, I think, uncomfortable with the idea. Judge Mark Pittman, in his order vacating the loan forgiveness program on the grounds that it violates something called the major questions doctrine, essentially highlighted the fact that Congress has proposed bills to eliminate debt in the same manner that the administration has, which evinces a notion that Congress itself doesn't believe the president to have this authority. Indeed, Speaker Pelosi herself disclaimed any notion that the president has this authority, I believe, last year in a press conference.
Okay, Charles Brandt, Young Voices commentator at GW Law School. Thank you, Charlie, for taking the time to be with us. We appreciate it.
Thank you so much for having me. I very much appreciate it. And happy holidays to you and your viewers.
You too.